So thank you so much for having me. Thank you for that kind introduction. But thank you particularly for the following, which is that I finished writing the book Rogue Justice 2 years ago. And it's time for a new last chapter. And if you hadn't asked me here, I might not have tried to put my thoughts together on where we stand now, because where we stand 2 years ago is interesting, and I'm going to let you know and talk about it, but I really want to bring the conversation up to today. The second thing I want to say is that when I finish and we do the Q&A, feel free to ask me anything about this entire area. I'm obviously not going to get to the whole host of issues that I've been asked to speak on. I'm going to try, but anything that has to do with terrorism, the war on terror, I'm pretty happy to discuss, and I'd be really interested in what's on your mind as opposed to what's on my mind. So I'm going to begin where anybody in my profession begins, and that is on 9/11. And let me preface that by saying that what I've done since 9/11 is found an institute, a think tank, that is now more than 15 years old, that is dedicated to creating a conversation between national security and civil liberties. And we do it in public events to the tune of dozens and dozens a year, and in private events. We've had top officials in every area of government, both in the United States and outside of the United States, come and talk to others, those who are both like-minded and those who might have differences of opinion. And I'm a real proponent of the fact that exchanging ideas, whether you think you share them or not, is more important than anything else. And so you're going to hear that in part of what I'm trying to lay out, which is a serious concern for security and a serious concern for civil liberties and constitutional principles. And so that I want to talk today about what I think has happened since 9/11 in the tension between these two areas of American life and thought. So I'll begin. On 9/11, as I'm sure many of you know, given what you do for a living, I looked at the list of who's here ahead of time. Within 3 hours, inside Washington, officials, ex-officials, experts on terrorism, and others had found their way to Washington to meet, most of them at the FBI, some of them elsewhere, to figure out what to do on two fronts. One, to prevent what everybody who knew anything about al-Qaeda was sure was going to be a follow-on attack, and two, to prevent any attack that might be planned for the future. So you had an extraordinary amount of expertise thinking about the intelligence challenges, the law enforcement challenges. But the first thing that happened of consequence after 9/11 was that night in the White House. And the first things you have to know about the policies that came out of the post-9/11 atmosphere in terms of the executive is that everything happened rapidly. Some of this is because many of the things that happened after 9/11 had been proposed in the years before 9/11 and hadn't taken place yet, and others because they were new and they saw a situation and thought of some creative response to it. But it's very interesting what the actual first document that came out of the White House was, because it told you a lot. And I think it has consequences for today. It was the draft, the original draft of the authorization for the use of military force, which you still see debated in the headlines, like, are we going to get a new authorization for the use of military force, maybe, after all these years? And what's interesting about the use of that initial draft, which Congress saw, but none of us probably have seen, was the language. In addition to the language that passed Congress, which was the language that said that the president was authorized to use force against any and all of the individuals who conspired, planned, helped, etc., in carrying out the attacks of 9/11, they also had this clause, that the president was also authorized to use force to deter and preempt any future acts of terrorism or aggression against the United States. You have to think about that. There was no enemy. There was no geographical limitation. There was no definition of the kind of terrorist he meant or the kind of aggression that was meant. It's almost inconceivable to me to imagine that this text went before Congress in the days after 9/11, in the 24 and 48 hours after 9/11, and Congress said no. They said no. You cannot have this power to just define any enemy you want as broadly as you want without geographical, political, ethnic, any kind of limitation, and they didn't give the president that power. But it was a sign of what was to come, because if you had to categorize one of the basic tenets of policy after 9/11, breadth, for lack of a better term, was the driving force. It seemed that the lesson that American public and American officials took home was, what weren't we doing right? It might have been a lot of things, but one thing we needed was more. We needed more intelligence. It wasn't necessarily better intelligence. We needed more. We needed more rather than less captives. We needed more troops. We needed more. It was the initial reaction, and I think it's lasted in many ways to this day. The second reaction, which was also clear in this first attempt to get an authorization for use of military force, the AUMF, was presidential powers. Immediately, the powers went to the president. And when you took together the fact that the president was who was authorized to carry out this force, and also the clause that was taken out, which was basically the president can determine who the enemy was and who the enemy wasn't, the leap to the need to have presidential authority, and not for a balance of powers, even though this was a congressional authorization ultimately, was also a sign of what was to come. So in Ashcroft's words, John Ashcroft, who was then Attorney General, he explained this as the need for this new legislation, whether it was the authorization to use military force, the Patriot Act, the November 13th order, which set up Guantanamo and ultimately the military commissions. Time and again, he described it as the survival of our society, which is the third prong of this, that what we faced after 9/11 as a society was an existential threat. And the existential threat wasn't just to our life and the lives of those among us. The existential threat was to who we were. And so what you see happening very early after the war on terror is a debate that's sort of been lost because of all the partisan wrangling that goes on about who we were and who we wanted to be in the world, something that we really haven't resolved to this day. The Patriot Act, which is now sunsetted and been replaced by the USA Freedom Act, is similarly unspecific in many of terms which I think a responsible Congress would have made more specific. There's no definition of the enemy, there's no definition of combatant, there's no definition of belligerent, there's no definition of fighter. What there is an expansion of authorities for investigation and other purposes to detect and deter terrorists, all of which were necessary tools in fighting the war on terror. But this idea that more, wider, cumulative was more important than specific is going to come back to haunt us later, as you will see. So in this effort for more, quickly, the first thing that happens is the rounding up of individuals who are Muslim, Middle Eastern, South Asian, kind of randomly, in a sense that both Americans and aliens that we rounded up maybe 1,500 or 2,000. Again, not individuals that there was evidence on that the authorities could suspect for a reason or another. It was just the faster, the more, the better to get a sense. And part of this may have been cosmetic, and part of it may have been real, and part of it may have been just, we're going to do everything we can. But the fact was that instead of rounding up the 12 individuals who might be here on passports from some country that might have been involved in 9/11, it was this massive roundup, none of whom were ever indicted for the things that they were rounded up for. You're going to see this same pattern when it comes to populating Guantanamo. Guantanamo ends up having 800 individuals. Nameless, faceless. They arrive at Guantanamo without biographical material. There's a knapsack full of random pocket material that they take from different detainees. They have no idea who they are. They call the French police, they call the Spanish police. Do you know these guys? Will you come and interrogate them? But again, it was about breadth and more and a wide net. And so in addition to having individuals whose names we knew, who were the top leadership of al-Qaeda, some of whom are now in Guantanamo Bay detention facility, there was this random sense of, let's just pick up who we can. They're in Afghanistan, they shouldn't be here. Let's just pick them up, and they ended up in Guantanamo. There was also a sense, and this is where I think it was the most pervasive, and when they write the history of the post 9/11 era and the abuses of civil liberties, they're going to write about surveillance policy. One of the lawyers in the Bush administration who came in, I'm going to talk about in a minute, and talked about surveillance policy, also uncovered the torture memos. And to his mind, the surveillance authorities that were given far surpassed what was wrong with the torture memos. Is not because he's a supporter of torture. It's because to this day, Americans still don't understand what was done in the name of national security after 9/11. And there were two levels of policy. There were the policies we knew about. The Patriot Act allowed for expanded powers that became warrantless surveillance powers. But there were also secret powers in a program that became known as Stellar Wind. And I invite you to read the massive report on Stellar Wind that is not in chronological or any other kind of order. But if you like putting together puzzles, it's fascinating, the debate that went on, and who stood up to this and say we can't do this. Among them, a former speaker you had here, Michael Hayden, who was like, but there were these secret policies that we didn't learn about for another decade, and there were well-known policies. But the basis of this policy were not individualized warrants, not putting something before the classified information court, the FISA court, but as much as you can get. The theory was, if you get everything, even if you include materials from Americans, we don't have to suspect them. You'll be able to use some kind of search, and you're going to find the person. You're going to find what you need. So again, it was more, not better. And eventually, this same habit of mind gives birth to the idea, I think. So there are a couple of things going on here. One is this deep sense of insecurity on the part of Americans, like, what did we do wrong? 3,000 people died, we didn't defend ourselves, we're gonna fix this. But the first thing in the minds of many in terms of how to fix it was, who was responsible? The law. The law was responsible. The law was in our way. The First Amendment, protected people being able to say the things they wanted to say. The Fourth Amendment we need a warrant to go after people. The Fifth Amendment, we can't abuse people to get information out of them when this much is at stake. The Eighth Amendment, we can't abuse them. The Fifth Amendment, they deserve a lawyer. So one of the other things that happens after 9/11 is the revocation of a number of the amendments without clarification. Nobody gets up and makes a speech about it. It's a slow process, a bit-by-bit process. One of the things that happens is that individuals here in the United States are declared enemy combatants. What is an enemy combatant? In this case, an enemy combatant was somebody who existed outside the terms of the law. So in this case, the U.S. citizen I'm referring to here was Jose Padilla. He was taken out of federal custody, put into military custody, and kept there for 3 years without access to a lawyer or to any kind of due process or trial. And then, of course, the most egregious sign of a country that has abandoned its laws was the implementation of the torture policy. But again, enemy combatant was something Americans knew about. It was in the headlines. This was not secret. He was dragged away from his lawyer and from from the prison in New York, but it was not secret. The torture policy was secret going forward. So by the time the summer of 2002 comes around, you have a vastly different sense of the law and what it should be. And you have a number of policies in Washington that are based on a disregard for the law, and another with just contempt for the law. The policies that were secret, that attempted to get around their surveillance laws, et cetera, they just were contemptuous of the law. Otherwise, that would have been a transparent process that they would have, one way or another, tried to vet through Congress. And the term I'd like you to think about, which I think of a society we haven't thought about, is a term that was provided by White House counsel Alberto Gonzales at the time, who got into a tiff with General Colin Powell, who was then Secretary of State. And Colin Powell was uncomfortable in this specific instance, with the decision to walk away from the Geneva Conventions when it became to the American detention and treatment of prisoners. The United States decided they weren't going to be prisoners of war, therefore they wouldn't have the protections of the Geneva Conventions. And Powell had a number of reasons that he wrote down in a very long memo to the White House to explain this. And in the memo, what he said was, among other things, you are putting American troops at risk because the Geneva Conventions protect us. This is an issue of reciprocity. We step over the line, they're going to step over the line, and there were a few other reasons. And Gonzales does not want Powell to win with President Bush. And so he writes his own memo, and he is very clear. And what he says, in addition to all the reasons that he thinks that this will be helpful to not follow the Geneva Conventions because of things we need in terms of information and other things, what he says was, listen, this is gone. This legal structure this mindset that we're in, it's quaint and it's obsolete. And although he was referring to the Geneva Conventions, for me, it seems like the right title for what people in general were thinking in trying to grapple with what to do in response to 9/11. And the real question, which we never really debated, was this that I referred to before. Was this quaint and obsolete? Were our laws outdated? Was the 21st century so different than the 19th and the 20th century that we really needed to rethink our basic principles, our basic laws, and who was privy to our protections? You can be sure with this kind of overstepping the lines of the law, and it's not just the law, it's the heart of the law, the sort of sensibilities that this country was built on, there was going to be pushback pretty fast, and there was. I think that civil libertarians were out there, day one with you can't have warrantless surveillance and you can't detain people without a lawyer. That was to be expected. But the most important pushback came from inside the Bush administration. And by the end of 2003, you had lawyers throughout the Department of Justice and elsewhere at the Pentagon saying, you can't do this. And then one lawyer went from the Pentagon to the Department of Justice and actually saw the secret memos that had justified the warrantless surveillance, the massive surveillance, the torture, the treatment of detainees, the exclusion of prisoner of war guarantees. And he looked at the memos, and it wasn't just that they were morally offensive. I'm sure he thought they were morally offensive. But it was also that they were legally wrong. That they forgot some of the most important cases on which the law of the land was based when it came to these issues, namely presidential powers, and that they were just bad memos. And so in a kind of sleight of hand, he tried to revoke some of the memos and to get others of them rewritten. And before he had accomplished his task, he left for whatever reasons, to spend time with his family or something like that. And, but it was a very important moment because the dissent from within is just as important, if not as important, from dissent from without. That issue of rescinding the memos and getting the White House to comply with the law was handled further by Jim Comey, who was at the time the Deputy Attorney General, and who went to the White House and said, you see this surveillance policies that's going on? You actually can't do that. And so you need to return these issues to the court that's created for this, the classified court, the FISA court, and then eventually Comey and the lawyers that worked with him intended to turn this into law, and they turned it into law. And I made a list of all of the things that came up during the Bush administration that actually rescinded, rebuked, rewrote, or reformed what had happened in the initial 2 years in the war on terror. And it's actually, I'm not going to read you the whole list, but it's rather staggering. So I'm just going to tell you some of it. First is what I just talked about, which is at least codifying that which it had been outside the law in terms of some of the surveillance powers. In terms of detainee treatment, the Congress under Bush passed the 2005 Detainee Treatment Act, which protected detainees from cruel and abusive treatment. In 2006, the Military Commissions Act was passed to create military commissions that actually had something to do with a lawful regime. In 2000 well, I want to get to the end, but in 2008, Boumediene, the Supreme Court decides that the detainees at Guantanamo Bay have the right to challenge their detention here in DC court. In addition to this, although I get that none of the top officials were prosecuted, individuals were tried in courts martial and convicted for killing one individual while they abused him in custody in Afghanistan and for the excesses at Abu Ghraib. So to say that this was a monolithic story would be wrong. A better way to say it would be that much of what happened in the Bush administration was secret until the years of the Obama administration. And what Obama did was, in some ways, in legal framework, continue a story that had been started by his friends, the constitutional lawyers and others, inside the Bush administration. But what he also did was to establish a tone that the Bush administration had never been willing to establish. It was far enough away from 9/11 to be able to say, hang on, it's not just legal rethinking that we need some moral rethinking. And whatever we actually do, let me tell you what I wish would be done. This is Obama. And within 24 hours of being in the presidency, he said, we're going to end torture. Bush had essentially ended torture. He had closed the black sites. He had moved those individuals to the CIA, to Guantanamo. But he hadn't said, I want to end torture. He hadn't declared that it was a policy that was over. He hadn't said, you know what, after 9/11, we were going to do everything we could to make this country safe, and we exceeded what we should have done, and now we're pulling back because we recognize it. He left it there as if it were something that could be revived and for which there didn't really need to be a discussion or accountability. And Obama picks that up and he says, I'm going to be the moral guy here and I'm going to close Guantanamo. Bush said he wanted to close Guantanamo, right? Bush got 524 individuals were released from Guantanamo on Bush's watch. Obama wanted to continue that and bring it to a close. But Bush never got out there. He said he wanted to close it, but he never got out there and said, I'm going to close this thing. It was a matter of tone and direction and moral authority. And at the very beginning, that is what Obama contributed. But there are other things that happened on the watch of the Obama administration, and I think they're important. One of them, which you might not associate with this story, but it's actually very important today here in the DC courts, is that the Obama administration very quietly tried to create the conditions in which military commissions would not happen at Guantanamo anymore, at least not in the future. The first thing they tried was to bring the 9/11 trial, which has still not even begun, how many years later, to federal court, and for a number of reasons, which we can talk about later, that attempt failed. They are still in Guantanamo Bay, still not tried. But the other thing he did, and this is something I don't know if people have connected the dots, was to begin to use the federal courts for the kinds of individuals who were being held as enemy combatants at Guantanamo Bay. Mostly foreign-born individuals who had not been in the United States, who conducted lethal attacks, often or plotted or conducted lethal attacks, and those attacks were carried out abroad. And so today, in federal court, Abu Khatallah, the conspirator in the Benghazi attack, was convicted, and we can talk about that trial if you want. Was convicted this afternoon after a very long trial, and what I believe is the longest deliberation of a jury in a terrorism trial ever. And I will double check that tonight, but I'm pretty sure. And they kept doing this. In fact, there were two cases, one of which I went to, which was a case, but they were both the same, of a case of battlefield situation with military, in which military individuals were killed in uniform. And the case was brought in federal court as a terrorism attack, as a murder case. And so what the Obama administration was trying to do was to expand the ability of the federal courts to try all these variety of cases that might fit in to the framework of what a terrorism trial is, hence rendering the military commissions process not necessary. And We'll see what happens with that. In terms of surveillance, what did the Obama administration do? To civil liberties advocates, the answer would be all too little. In terms of torture, and I'll come back to these, what did the Obama administration do? Many civil libertarians would say by not holding anybody accountable at the highest levels and by making the decision to go forward instead of backwards, that too was all too little. And in terms of the targeted killing policy, which is Obama's policy, not really predicated on Bush's policy, there was put in place a policy in which targeted killings were decided by the president in the White House with his national security advisors in a way that many feel should have been either put through a drone court, so like a FISA court, a classified court, or some other kind of transparent procedural process. So what Obama does is very interesting. In addition to introducing this moral tone, following up on the strengthening the legal system, the legal terminology, he does a lot of symbolic things. He gets rid of the term enemy combatant. It's not going to be used on his watch. He gets rid of the term Islamist terrorist. It's an Islamist extremist, right? It's a violent extremist, that's it. It's not going to be used on his watch. And he says to the American people, look, trust me, I'm a good guy. The guys around me are good guys. We're not going to torture anybody. We don't have to hold people accountable. We're going to try to get people out of Guantanamo Bay. We're going to do our best. We're going to decide who's going to be killed in a way that makes sense. We're going to bring in our military advisors, our intelligence advisors. This is going to be eventually as constrained as possible. We are going to, as a bottom line, walk away from breadth and come back to specificity and focus, to good old-fashioned way we think about adjudicating guilt, innocence, crime, and war. And yet, the two most important things that happened on Obama's watch are the creation of two studies. And I know people like to make fun of him, just all this process and where's the there. But there are two studies, actually three studies, that take place, investigations. One is Dianne Feinstein's torture report, which they spent, a year and a half involved with 6 million documents buried in some kind of bunker to get this 6,000-page report, of which we've seen 600 pages. It's enough. And to really look at who was tortured, what did it look like, who did the torturing, what kind of techniques were used, what was the information, what were the questions asked, what was the information given, et cetera, et cetera. Another report came out, was commissioned right after the Edward Snowden revelations. And that report essentially was, Obama picked together 5 national security experts from the environs of academia, Washington, and the security community. And he asked them to look at these policies that Snowden had revealed and to determine whether they were useful or not. And so that was another very important report. And then the Privacy and Civil Liberties Oversight Board, which is a bipartisan, nonpartisan, executive, independent research body, a watchdog body actually, he asked them to look at the same thing. Look at what Snowden revealed and tell us, does it work? What is this from a national security point of view? Let's cover that basis first, and then we can talk about the legal basis of it. And by the time Obama left office, what you see happening is the Patriot Act sunsets, including the provisions that the Privacy and Civil Liberty Board said should not be used anymore because they didn't work. Torture is really off the charts, largely because the Senate Feinstein Committee Obama's ended it, but after the torture report concludes, torture doesn't work. And the President's Review Board, when looking at the surveillance programs, says the same thing. One of these programs works, and the one that doesn't work, we're going to end. And so it's interesting that in the pragmatic presidency, which is how we think of Obama, you end up with very pragmatic answers to why here's the moral president with the moral leadership. Why are we talking about how we shouldn't have torture again? Because it doesn't work. Not the moral issues, because it doesn't work. Why should we let the Patriot Act sunset? Yes, it was declared illegal by an appellate court in New York. But why did Congress let it sunset? Because the Privacy and Civil Liberties Oversight Board and the President's Review Board said that Section 215 did not work. And so, to me, that's just something interesting to note. And by the time you get to the end of Obama's presidency, you have the legacy of the Bush era disbanding a number of the policies that had started during the early war on terror. You have Obama's pragmatic and, in some instances, moral overlay, getting rid of much of the rest. So what remains when Obama leaves office? What remains is a renewed surveillance policy, the FISA Amendments Act that was started under Bush and that lasts under him, 41 individuals who are still at Guantanamo Bay, no trial in federal court for the 9/11 defendants. You have a more contained, a more restricted, a smaller, a diminution of what had been a very large idea. And I will come back to this and say, you have a beginning of a restoration of the idea of focus and specificity. But you also have, and Obama's very clear about this, a restoration of First Amendment, Fourth Amendment, Fifth Amendment, and Eighth Amendment rights, very self-consciously, even if he doesn't use these terms. This is the constitutional lawyer in him and the civil liberties advocates, I think, that infused much of his administration. But now we have Donald Trump. And what's very interesting now is to see what's coming back. And so I thought I would, like I did at the end of the Bush thing, tell you, sort of what got resolved or addressed or beginnings of addressed. This is interesting to see what the Trump presidency has put back on the table, because for people like me, I was ready to retire. I'm like, wow, this is all done, and Obama got rid of most of it, and we're just going to have to live through the rest of this Guantanamo, et cetera, et cetera. Terrorism trials are back in federal courts. The surveillance issue is going to be debated in a very big way between public and private companies. It's going to be taken outside of this context of the war on terror, et cetera. But what do we have? The first thing we have is terminology. All of a sudden, these terms are back. We have Islamic extremism intentionally. Worse, from my point of view, is that we have enemy combatants back. So the second week of September, a US citizen was captured in Syria, put into US custody. We still don't know who he is, what his name is, we don't know anything. All we know is that he's been declared an enemy combatant. It's not just the personal issue that's at stake of this individual, although that's important. It's the larger issue of we have enemy combatants back. 2 successive administrations tried to walk away from the mistakes of enemy combatants. And an American enemy combatant, what is that exactly? An enemy combatant can be at Guantanamo, but a US citizen can't be at Guantanamo. So what's going to happen with this individual who we still haven't heard about for 3 months is, to me, one of the biggest worries right now in what may be coming back. We also have new references, as you know, to torture. They started during the campaign, waterboarding and worse. The use of torture by a number of people have mentioned it. And I think, who knows? It could be provocation. It might be real. The detention authority, the idea that Guantanamo will be reopened for new individuals. This case that just concluded in federal court today here in DC is very important on this point. It's an individual, a non-US citizen, has nothing to do with being in the United States, convicted of a crime, of a terrorist of an attack in Benghazi, Libya. Everything about this was foreign abroad, except that it was the US Embassy. And he was brought here, he was tried here, he was convicted here. That kind of individual, under the new language of the Trump administration, could end up in Guantanamo, which may mean he never gets tried, which brings me to my next thing, the military commissions. Of all of the things that Obama did, one thing he did was to revive the military commissions. And I'm sure there's a host of reasons for this, and we can talk about it afterwards. But at first he suspended them, and then he changed his mind and revived them. And in so doing, we now have a situation at Guantanamo where we have individuals who are pretty much assumed to be those who conducted the 9/11 attacks and other lethal terrorist attacks against Americans, who a lot of people say will never be tried, maybe not in our lifetime or in their lifetime. And this is actually a serious problem right now, because the military commissions, which have stumbled in place for a very long time, this month had a tremendous setback. And the setback was that because of classified reasons that had something to do with attorney-client communications, we think, the civilian defense attorneys resigned from the defense team for one of the terrorists that was going to be tried, was in pretrial hearings at Guantanamo. The Chief Military Commission's Defense Authority agreed with that decision, essentially approved it. That person was put in custody for being in contempt of court. And there's since then been a back and forth about who's right and who's wrong. But the fact is, this trial is far away. And it's getting worse and worse. When you start convicting, charging and holding in contempt of court military officers, because you can't quite maneuver your way through the legal process that doesn't exist, this too is a problem, and it's happening on Trump's watch. And then just to turn to the one piece of Obama that his critics are most concerned with, the drone policy. Obama went way out of his way to, in his mind, in his administration's mind, establish procedures and processes that would, to their minds, justify targeting and killing individuals, including, as you know, American citizen abroad. The amount of drone, in all of the chatter that's going on in the last few months, the number of US drone strikes have escalated astronomically. And it's hard to get all the figures, but the figures are twice as many as last year in Afghanistan, twice as many as last year in Somalia, 4 times as many as last year in Yemen. And so we could talk about drones on another time or in the Q&A, but it's something to be concerned about in terms of all of the issues that Colin Powell raised, among them reciprocity and what this is going to mean in terms of the future security of the United States. And then the final thing I wanted to mention, just in this list of things to pay attention to, is this new expanded Department of Defense authority, surveillance authority, which allows warranted monitoring of US citizens and green card holders whom the executive deems to be homegrown violent extremists, which is a whole other story and a departure from what we've really been talking about in the past, because so much of our terrorism apparatus was designed for having a foreign element of some sort, association with a foreign terrorist organization, travel abroad to join a foreign terrorist organization, etc. So I think we're standing at an extremely critical point in time, and that the lessons are many. One lesson is there has to be a reset button. You can't be so determined to win the argument that you're not willing to say, we're resetting it, like the Bush administration did. We can reset this. The second thing is, you can't just fix things privately by yourself inside the executive because of trust me government, which is essentially what happened on Obama's watch. Because as many said at the time, these are powers that if you consolidate them in the White House, in the presidency, can have a lasting effect if it's not you and the things you want that are in the presidency. And the third thing is a kind of very weird just that's echoed to me throughout studying this. And that is this odd association between two of the themes that go on here. One is this insistence on breadth, more, 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 which turned out not to be better, 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 better. More detainees at Guantanamo didn't let get us to the people who were actually the individuals we had to worry about. More surveillance did not, according to this report that led to the sunsetting of the Patriot Act, specify who it was that we needed to actually watch. And the reason this is important is because I would like to be safe. I would like my children to be safe. And one of the premises of when you think about guilt and innocence and suspicion and investigation is you'd like it to be based on facts and evidence and focus and specificity. And that's how you're going to get the people who are the people who want to hurt you. That seems to be the lesson of this, and it's not just because I'm saying it, it's because that's what the torture report said, that's what the surveillance reports said. And the reason that's interesting is that when civil liberties advocates and lawyers and all that, when they talk about protecting these rights that are in the Bill of Rights, what they talk about this from a very moralistic point of view, that there's a fabric of our nation, this is who we are, this is what makes us unique as democratic individuals. And I agree with all that, and that's very interesting. But what's really interesting about it, and it's worth some reflection, is that somehow the Founding Fathers, who I don't think foresaw 9/11 or anything like 9/11, created a series of principles and premises in which they went out of their way to say, we aren't going to have a general warrant. We're not going to do that. That was one of the basic things they wanted to create in this new law here. We are not going to have a general warrant. You can't just say somebody in that neighborhood is guilty. And you know what? The president can't decide who's going to get killed. And you know what? The president can't decide who's going to be detained. There's going to be a process, there's going to be facts, and it's going to be specific, and it's going to be based on evidence. And what's so interesting about that is that if you look at these reports that were commissioned by Congress, that were commissioned by the president, that were commissioned by the executive rules, you will see that time and time again, what we're finding is that those principles, which are fantastic from the point of view of thinking well about being in a democracy, are actually the principles that keep you safe. Having the smartest way to find your enemy rather than the let's round up the neighborhood is actually what will keep you safer. And so to me, that's been the lesson of the past 15 years. And of all of the things that can happen now in terms of changing the fabric of our national security mindset, the thing I would recommend the most highly, containing all of the elements I've talked about the national security policies, is that to move away from our tried and true method of use your brains, use your facts, use your evidence, rely on specificity, that ultimately, for reasons that go back 225 years, is what keeps us both safe and living in a democracy. So, thank you.
Okay, for those who have been here before, I apologize in advance for this, but we do have some Q&A rules. The first rule is, again, we do tape this thing, we're recording it, and so we would ask that you please wait for the microphone before asking your question. The second thing is, we'd like you to tell us who you are and where you're from, and try to avoid the acronyms that people don't understand what they are. The third rule is, you only get one question. The fourth rule is, we know everybody likes to put their question in context, but if you could keep that context short and actually ask a question, that would be great. And then finally, your question should relate to tonight's topic.
Hilarious.
Yeah, Chris Bailey, National Intelligence University. My question relates to your comment about combatant status for an American taken captive in Syria. Are you saying that that person should not be treated as a combatant, but should be tried in federal court?
That's, yes. I'm saying that you can't be kept forever in a black hole of what happened in the Obama administration is they considered a number of individuals combatants, right? But for those that they captured and didn't kill, they kept them Abu Khatala among them, in one status for the purpose of questioning them, and another status for the knowing they were going to put them into the federal system. That's what we have available to us. Unless we want to, establish, camps, detention centers as a wartime scenario in an undefined war, without any barriers or, So I don't see. Do you see another option?
They are taken captive under the law of war, and they can be held to the duration of hostilities.
Yeah, but and that would be defined by what? The death of bin Laden? Like, what would be the end of hostility?
That would be until Ayman Zawahiri sits on an aircraft carrier in New York Harbor and signs an instrument of surrender.
Okay. So actually, if anybody in either administration had been willing to define the end of hostilities, which no one's ever been willing to do, I think that would have been. But what they'll say? Nobody's going to agree with that. They're going to say, we got Hamza bin Laden. We're not going to accept that. So I think that unless you want to live in a country with a perpetual state of war and a perpetual prisoner population, when it's an American citizen, yes, especially when it's an American citizen, absolutely. How is that different than the foreign fighter that we arrest because he got to Turkey and we intercept him before he actually gets to Syria?
Well, I could give you the case of Enrique Taratito. We had an American citizen who was captured in Italy during World War II, brought back to the United States, held as a prisoner, filed for a writ of habeas corpus, and the federal court said no.
Right.
American citizen, you're not going to get an Article 3 hearing. You are a prisoner. And actually, that's actually good news for him. Because if he had been released, he could have been tried and executed for murder, where otherwise he was just held under law of war, and once the war ended, he probably got deported to Italy.
It's a completely valid point, but you understand that in this current circumstance, there is no end to hostilities the way we've constructed this war. But it's a valid point. Again, a discussion we need to have. We're not having it.
Yes, ma'am. Mike Smith. I'm actually a science and technology guy. I used to do other things in a previous life. To kind of satellite on that, are we at war?
Yes.
Yes or no?
Yes.
Okay. In that case, you then presume that the law of armed conflict applies.
I wish.
In all cases.
If somebody said to me, like, if you could fix one thing about the early war on terror, what would it be? Having prisoners of war would have been my answer. Deciding not to have prisoners of war, to step outside of that entire paradigm and say, no, we're not going to have prisoners of war, we're going to call them detainees because these laws don't apply, was an absolute mistake. Now, when Obama came into office, he said, I'm going to figure out what to do, I'm going to close Guantanamo, and I'm going to create a detention policy. Did we ever get a detention policy? I still don't think we have one. It would be, if we're going to participate in this war, we need a detention policy, I think. But we've gone this far, being both, it's such a good question. We've been both at war and not at war, on and off for 16 years.
Thank you, Dr. Greenberg. That was very provocative. I'd just like to follow up on the last. Oh, my name is Joseph Correo, and I'm with the Transportation Security Administration. I'd like to follow up on the last question. Asked, are we at war? You answer quickly and with confidence, yes. But then you say, or suggest, that we can't know when we're not at war. If we can know with confidence that we are, can't we know with confidence that we're not? And the obvious question is, how do you know?
Right, because we have an authorization for the use of military force that we rely upon to kill people around the world with drones and with other kinds of military actions. To me, that is we have an active battlefield. But the reason this is such a provocative question is that since 9/11, we have tried to pretend that we're not in this gray area between crime and war. And we've tried to negotiate this space. And all of my remarks and these questions come out of the fact that we've consciously done it, but we haven't consciously thought it through. And the reason is it's too hard. We have the federal courts that can try people. The military commissions don't work. If we can't try the 9/11 defendants, what? So we are in that space. And so if you ask me if we're at war, I have to say if we're killing people around the world in order to make ourselves safe because they think that they compromise our security, then that sounds to me like we're at war. But if I walk into federal court and I see uniformed officers testifying about the death of their comrades, their associates on the fellow soldiers next to them because an Al-Qaeda operative attacked them, I'm aware of the fact that this is a very confused situation. I could try to pretend it's completely clear. It's not. But I think this is the reality we live in, and so we pick and choose, I think.
I'm Jerry Meyerly. I work for the Center for Naval Analyses. I think one thing that was missing from your story, especially about the Obama administration, is that when ISIL, flooded into Iraq, he presided over a massive expansion in operations in Iraq and Syria and a huge escalation in the conflict there, and really the starting of a new war in Iraq and Syria. Massive expansion. Started out with a huge air campaign. Then we put forces on the ground. Then there was a further expansion in the air campaign, more forces on the ground. It went into Syria, and it's just basically a big war. And he did that under the authorization of the original 2002 authorization, which enabled us to go into Iraq. And then they based it on the AUMF, which was based on Al-Qaeda, but
Right.
That's not what ISIL is.
Yeah.
And so if that happened under the Obama administration because of these JV fighters that we called ISIL, how do we know that's not going to happen somewhere else? This happened under the administration that you say rolled all this back, that got us back to a more discriminant policy, that got us back to doing less. Well, he actually expanded us to do more. So if he did that, then where is this heading? In the next administration after that, what happens if something pops up somewhere else? What's to restrain this war machine that is just going to be triggered anytime there's a series of attacks? And what is the steady state? How do we get down to, if this is a forever war, then how do we define it as being the steady state in the normal series of operations and not some period of escalation?
So here's what I think is going to happen. I think that and don't forget, there are a lot of people who say Obama kept us out of war, right? That Obama kept us out of war. There is that tagline, So I think what's going to happen, and this is both the good news and the bad news, is that we've been focused on non-state actors now for the better part of 16 years. And towards the end of the Obama administration, and now big time, we are faced with threats from nation states as opposed to non-states. And as that paradigm shift becomes real, and the possibility of even the remote possibility of conflict with North Korea, Iran, whoever, Russia, China, you name it, that as the nation state begins to re-emerge as the enemy for which the national security apparatus is poised, I think that's going to become a dominant piece of the discussion, and there are much clearer laws, actually, in place for how that will play out. Now, that doesn't mean we're going to have less troops, more troops, whatever it is, but it means that, in a way, I think we may be, I don't know if it's backwards or forwards, but I think the nation state is going to change this conversation, the nation state actor. But we'll see.
Ken Marcourt, TV producers. Yeah, in most of the places we have taken prisoners, we could claim to have been authorized to be engaged in those areas, Afghanistan, Iraq, whatever. There's no such legal authorization for being in Syria. Does that muddy the water even further?
In what way?
If we took prisoners in Syria.
Oh, yeah, no. We don't have a plan for taking prisoners. Right now, what we do, as far as I can tell, is we give them to the host country or give them to a nearby country. But it is not our plan to take prisoners. And so, you know, I think we are at war in a lot of these places. And you mean just because we haven't declared war? Is that?
We have a big need for authorization
Yeah.
in most of those countries. Libya,
Yeah.
no-fly zone. I don't know about Yemen, but Iraq and Afghanistan invited in by the, well, not exactly invited in Afghanistan, but
Yeah.
legitimate defense, I would say. But Syria, we just came across the border.
Yeah, no, it does muddy the waters, but I can't answer how to get out of them muddy waters. Sorry.
No one can.
Yeah. I wish I had the magic answer.
Okay.
I'm Tom Barnett. I'm an analyst with Institute for Defense Analyses. So what would you say to the pushback that said, oh, specificity and focus on the actual bad guys by name is something that's evolved over time, and it's exemplified by targeted killing by drones? I would just add that in the initial days after 9/11, we had trouble even figuring out who these guys were because we couldn't spell their names. Now we have a massive database that we can run algorithms against, and we pretty much can pick people out by name, and we
that's-
eliminate them. Sounds
Right.
like specificity to me.
No, I know, and I thought about that when I was putting this together, and I'm like, I really hope nobody brings that up. But I do have to say, I did think about it. And what I have to say to that is that the problem with the targeted killing policy is not whether it's, remember it used to be general, it used to be the targeting an area rather than an individual, and Obama's whole thing is getting it down to less than 0.1% or whatever, 0.01% of getting the person that they really wanted, is who's deciding who gets killed. You know, is how that process is taking place. And it's not a transparent process, and we don't know, and that's the part of it, that it's not so we're partway there, but we're not a way there that would actually recoup what it means to be declared guilt and innocence. With who has the facts? Who knows? What are they? So that would be my answer. But yes, your point is well taken.
Lee Green from the Army. My question is we know that Guantanamo is a problem, but do you see any way to end or come to some kind of resolution for Guantanamo Bay?
There's 41 people there. How hard is that? Do you mean politically? Do I see how to politically maneuver these waters? Because that's the only thing standing in the way of Guantanamo. We know they're not coming here. We got that, okay? So, and 5 of them have already been cleared for release under President Obama, right? So we're talking about 36 individuals. Just so you know, those are the same, that's the same number that President Bush's team said. You know, how many are diehard, no matter what, we're going to have 36 indefinite detainees, forever detainees, as Carol Rosenberg from the Miami Herald calls them. It's always been the same number, and my guess is it's the same number of individuals. I think at this point, given how old some of them are, how crippled some of them are psychologically as well as otherwise, the cost, $11 million a year per prisoner, your tax money, I don't know about mine, but it's a lot of tax, you know, is to just be more confident as a nation and close it and either put them in custody in other countries or in a process. Try them or release them. It's more important than keeping them, I think that. In terms of the military commissions, which is the other part of it, the individuals that are held in military commission, for the life of me, if I don't know why Congress wouldn't just say, return them here, try them in Virginia, and let's be done with it. This is not, as Eric Holder said when he tried to move it to Manhattan and he got criticized for it, we have the evidence. We know how to, we have the information, we have the evidence. Now, they'll say there isn't evidence, maybe it's tortured evidence, maybe. The federal court, I go to terrorism trials all the time. It's one of the things I do. You have no idea how much leeway judges give to the government to present these cases of material support, let alone the individuals accused of 9/11 or of the USS Cole in the case of on the Shiri. And so I have tremendous faith in the federal courts being able to be flexible enough, the judges to be strong enough to get these cases through our system. And it's not that hard. We've done it before. We did it in the 90s. We've been doing it consistently throughout the Bush and Obama years, especially these last years. One Guantanamo detainee was brought to federal court, and because he was acquitted on 283 of 284 counts, that was the end of that. I just think we should have more confidence in ourselves and our customs and our ways. That's what I think. And that would close Guantanamo, and we could use the $11 million per prisoner per year for something else. Yeah.
Other questions? Okay. What? We got another? Yeah, you get two.
So a little clarity. So what are these guys? Are they detainees? Are they enemy combatants? Are they
They're both.
illegal?
No, they're both.
What would I call them? They're no longer not outside the purview of laws of armed conflict. They don't follow the standards that the Geneva Conventions were drawn up to apply to, which is armed combatants under authority of a state wearing a uniform.
They're enemy combatants.
Pardon me?
They're enemy combatants.
They're enemy combatants. Okay.
Non-U.S. citizens and enemy combatants. They're both. There are no U.S. citizens
And
there.
we choose to treat them as enemy combatants, and we choose to follow the Geneva Conventions, sort of.
In the original days of Guantanamo, when the military task force, the joint task force that received the detainees, when the first ones came, there was no policy yet because they were still trying to figure it out. And so they were told, listen, treat them in the spirit of the Geneva Conventions, but don't call them prisoners. Don't use the word prisoner, which is how we ended up with detainee, and don't say that you're relying on, but keep them in the spirit of the Geneva Conventions. And I think now you would have some version of in the spirit of how we think we should treat individuals in U.S. custody. They're treated, if you think about it, as if they were convicted, essentially.
Right.
That's what it is.
I mean, we're not going to let Khalid Sheikh Mohammed loose, I don't think, unless we want to behead him
No, I don't.
Down in Central Park or something,
Yeah.
just to set an example.
Right, it's not gonna,
but,
it's not gonna happen. They're not gonna let these guys loose.
As a related question, so we've got these guys, and let me think. Well, I'll recycle my thought here before I try and waste everybody's time on it here. So I'll defer to somebody who has a clearer question at the moment.
Yeah, I don't ask questions very often. My name is Duncan Brown, and I'm from the Johns Hopkins Applied Physics Lab. So my question is if you take these folks and you bring them into federal court, are you de facto conveying to them the rights of U.S. citizenry,
Or a U.S. person.
a U.S. person,
Yeah,
even though
so what?
even though they're a foreign enemy combatant?
So what? That's what we've done with Abu Khatala, who's, right, the Benghazi guy. That's what we did with the embassy bombings people who killed over 200 people in the East Africa embassy bombings in 1998. That's a tool that we have. That's the tool we relied on. Why is that a problem?
So the flip side to that is, having been on a panel that looked at privacy versus security, we had a huge debate as to not tapping, but looking at foreign telephone calls, if you will. And we basically said foreigners do not have the same rights as American citizens, and therefore, as the logic went, we could see who they were calling, and then, if necessary, go to a FISA court to get the transcripts and the taps from the phones. And so we said that those folks, foreign nationals, are different. They don't have the same rights as U.S. citizens in that case. But in this case, we're saying take a foreign national and enemy combatant and give them the right of a U.S. citizen by putting them in a federal court.
It's the right of the U.S. victims to see the person who perpetrated a loss of the life of their loved ones, to see them tried, to see some justice meted out. You have 3,000 individuals from the New York City area who have lost family members, who you have their family members of those 3,000, not to mention the rest of the citizens in the United States who feel still wounded by 9/11, who have had no sense of closure, of healing, of moving on from that moment because we don't have it in our capacity to try these 5 guys. I think it's incredibly important, if I didn't make this clear before, that we have that trial. I don't care at this point where it is, but I don't think the military commissions process is working in a very effective, efficient, or reliable way. I think they need to be tried. I think the United States needs to do everything in its power to help its citizens move on from this moment to whatever the next challenge is. And by not trials are for meting out justice, for telling the story, for vetting the narrative, and for beginning the healing process. And who knows how that all works psychologically, but I think American citizens have been deprived of something extremely important for them by the fact that these individuals have not been tried.
For what it's worth, I agree with you. I would ask you to tell the folks here, just to qualify things, how many trials have we actually had in Guantanamo, and how many convictions versus how many in the federal courts?
Okay.
Because I don't think people are aware of it.
Okay, so there have been 5 convictions. There were more, but they were overturned or vacated because of a long story, which I can tell you if you want to know. So there are on the books 5 convictions in however many years. Let's see, the military commission started in 2006, so 11 years. And there have been over 500 terrorism prosecutions since 9/11 in this country. Some of them lethal attacks, some of them planned lethal attacks, and other of them lower level material support, giving money, trying to give weapons and things like that.
The pragmatist in me would say the federal courts work.
Thank you.
I'll thank Duncan for being a catalyst to my question. So do I understand that, so a foreign person outside the United States has no constitutional rights. However, if that person comes to the United States for ill or for good purposes, then even though they're a foreigner, they are afforded the protections that a citizen of the United States has under a constitution. Is that the way the courts are now seeing these people?
They are considered, I would have worded it differently. I would say they're afforded the punishments of that they have to go through the potential punishment of the U.S. court, which is different than the rights of protection. If you ask them, do you feel your rights are protected in having to go to court before an American jury for the murder of American citizens abroad, I don't think they think of that as protections. I think what that is the Americans saying, we have a system for doing this in the most civilized way possible, and we're not going to give that up for anybody, not for those guys, not for other guys. And it's not really an issue about whether we give them the protections or not. This is our system, this is the crime against us, and we're going to address it on our terms, in our way, in our country. Unless you would prefer that he got tried in Libya, which is the other alternative that could have happened. And I don't think that would have satisfied people in the embassies who risk their lives, et cetera, et cetera.
Okay. The whole problem, of course, gets colored by the classification of information that points to the guilt of these people. We don't go out and sweep up innocent people so much anymore. Maybe we do somewhat, but not nearly as extensively as you pointed out early after 9/11. But it's difficult to deal with classified information in a
But
in a
it's
court.
not. I'm telling you. I've been to dozens of these trials. I have read through the transcripts of, I'm not going to tell you how many, it's embarrassing, of these trials. Classified Information Protection Act was set up, Procedures Act was set up exactly to handle classified information. Judges are, particularly some judges, are exceedingly learned and careful in how to do it. Defense attorneys aren't always happy about how it happens. Prosecutors sometimes have to give a little bit, but there are all these procedures for handling classified information in ways that sometimes the defendant doesn't get to see what a defense attorney might like the defendant to see. That's true, but it works in a way that allows the trial to go forward. And so I don't think that's the case. I understand that that's the argument made, but I can't think of a case where there's been I can think of a case where there's been evidence that was garnered through torture that wasn't allowed in, still ended up in a conviction. But in terms of classified evidence that look at even the Moussaoui case, to give you an example, where classified information was batted back and forth and classified witnesses, for crying out loud. So it's not true. The federal court system is immensely robust and flexible in handling these cases.
No, I thank you. I defer to your experienced, learned knowledge on that. That's not.
Thank you.
Okay.
Is that even in the conservative administration, the federal court system?
Yeah.
Tell us who you are.
I'm Elliot Hurwitz. I'm a retired person. Is what you said about the U.S. court system applicable in a very conservative administration that seems to be trying to manipulate the court system?
You mean this court system? You mean the Trump administration?
No, I don't mean the Obama administration.
Okay. No, okay. If the federal courts are interfered with politically, who knows what can happen? They are supposed to be a separate branch of government. They are supposed to have an independence, and if they do have that, and judges should stand up for themselves and protect that right, and they have every ability to do that. Do I think that the courts may be under an unusual amount of pressure? Do I think that there have been a number of appointments to the appellate level, the circuit court level, in the past few months that might adjudicate these cases differently? What, they're going to say these guys are innocent? I don't think so. So while there are worrisome concerns, the worrisome concern I would have is in a different direction, which is the independence and robustness of the courts, which I think is pretty consistent over time.
Thanks. Yes. I was just wondering, what's the moral and legal argument for, deliberately killing people in these drone strikes and other versus, trying them indefinitely or holding them indefinitely?
I would be the absolute wrong person to ask. I am not a big fan of executive killing, which is what our drone killing policy is, and I think it is, I'm very harsh on it in my book to the point where I think I am definitely the wrong person to ask. I think all of this is such a lack of trust in who we are and running from the wrong things and running towards the wrong things. And so, and the biggest worry about all this is if you compromise your respect for law and justice in one area, who's to say it won't happen and get hijacked into another area? And maybe people don't care, but for some reason, an accident of birth, I have no idea what it is. I'm extremely wed to this notion of using our system of laws and our system of justice the way it is, which brings me to what I was originally going to talk about and then decided not to. But I do mention it in my talk, which is that when Alberto Gonzales said, these laws are quaint and obsolete, and everybody just, because that conversation went off the rails, because then we got into torture and we got into all of these other untoward policies. We never as a country really had a discussion about what it means to live in the 21st century with our laws and our Bill of Rights. And what do we think they're quaint and obsolete, or do we not think they're quaint and obsolete? The conversation became so polarized and partisanized so quickly that they never really had it. And I cannot see the moment where we, as a country, will be able to have what I think is a very important conversation. And the 21st century is remarkably different than the centuries that preceded it. One of the biggest ways is that for all of my talk about specificity, we now live in a world where geographical boundaries don't matter like they used to. We live in a different place. We live in a world where identity is what you choose. It is, whether it's your gender identity or your national identity or your religious identity or whatever it is, you can select it in a way you never could before. This pace of knowledge, that, of communication is immensely fast. I don't have to go through all of this, you live, but we've been so tied up in this war on terror and but this issue in particular and who we should be afraid of, that we haven't been able to, as human beings, come to terms with our new century and what it means. And it may mean some very good things. We're just so distracted, and not thinking about what we should be thinking of. And the historical analogy that comes to mind is the turn of the 20th century. Because the turn of the 20th century was as disruptive in its own time to how people understood what life was about as this century has been for us. In sense that communications were all of a sudden of a different magnitude. Telephone, all of these things that emerged, flight, the pace of life, whether it was communications or travel, the technological changes that went about did something, I'm talking about Europe now, really did something to the European psyche. And you can read it when you read the historians of the time who were trying to figure out what happened. And the saddest part about it was that in Europe, because of World War I, a generation was killed off. We haven't had that happen here. Our youth, the people that are most in touch with these crazy changes that are going on, they're here. And it's our job as a country to be able to harness their talents and and to help them grow into figuring out what this century is supposed to be about. But we have not done this, and that's why the quaint and obsolete, for much as people make fun of it, was actually something I thought we should think about. What is quaint and obsolete? What do we want to keep? What do we want to get rid of? Why should it just be issues of personal identity that are all of a sudden up in the air? Why can't we be not fearful and brave about what we really need to address, which is, do our laws fit life is in the 21st century? And we didn't do it. So to your point, I think.
Hi, Stephen Jackson from SAIC. I just have a question regarding Iranian proxies, especially in Iraq. I was wondering any application of the AUMF for Iraq, if you think that applies, or if we capture Iranian proxies who might be Iraqi, might be from Iran, when does that constitute an act of war by Iran, or is that something that would be tried in the court system?
God. So let me just preface this by saying this issue of proxy violence and proxy warfare is the major project of the center this year. We just got a Carnegie grant to do a whole rethink of what it means to have proxy violence in the region. And this is one of the pieces of it that we're going to have to focus on. What is accountability in this system? How do you hold accountable? How do you attribute? So I can't answer it. But if you come back in 18 months or so, I'll have other people's smart answers for you. So sorry. Anyway.
Juan Perón, Kennedy School, Harvard. You speak with some sensitivity towards Edward Snowden. Have you communicated with him in the last 90 days?
No, have you? I do not communicate with Edward Snowden.
Okay, thank you.
Oh my God.
Any other questions? Okay, we're going to call it a night. Just a reminder, our next talk is December 19th with Dean Cheng on cyber warfare in China. And then on January 16th, Max Boot will be here. And have a safe evening and safe travels. And good night. Thank you.
Thank you.